So it's a very good question, and you might be surprised by the answer. If we get 100 calls complaining of medical malpractice, it's likely that we might be able to take one of those cases, maybe, and maybe none, because it is very difficult to connect all the dots to show that there was medical malpractice and to show all the elements of the claim.
Hello everyone, welcome back. I'm your host, Dr. Jim Hoven, and this is the Ramos Law Difference Makers podcast, where I get the chance to meet with cool people every single week, and we talk about things that are important, that are amazing, that are fun, that are different. And I hope you, as you're one of our difference makers, really get something from this episode, because today I have someone with me. She's an incredible attorney. In fact, cited as one of the best attorneys at her skill set and her specialty at what she does in the entire state of Colorado. And I have a personal story that I may or may not share as it goes through this, as it relates to what she does. But Miss Paige Singleton is my guest. She is so important to our firm. She has a very critical role in working with our attorneys at lots of levels and focusing on medical malpractice. And so what we're going to really dive into today is the concept of medical malpractice, what it is, how it works. And there's no one I'd rather talk about that with than you, Miss Paige Singleton. Welcome to the show.
Thank you, and thank you for the nice introduction.
Oh, absolutely. You're worth it, and so much more. And since since you come on board with our firm, I've had the chance to get to know you, a little bit and just visit with you. And it really, it's really impacted me, the heart that you have for people. And as it totally lines up with medical malpractice. And so would you start by just sharing with us a little bit about yourself and how you came to decide that you wanted to really understand medical malpractice and why it's so important to you?
Sure. So first of all, one thing that you need to know about me is I hate talking about myself.
Oh, okay.
I would rather talk about anything else. And that's just because, I'm a very humble person. And so I don't like to talk about my accomplishments, and I really try to focus on the law and my clients and what we do. But because I'm here and I'm being a good sport, I'll talk about myself a little bit. So I honestly don't. I was thinking about this the other day, and I don't know when I made the decision that I wanted to be a lawyer. What I always knew is I wanted to do something that was impactful, and I really wanted to help people. And when I was in college, I actually got a degree to be an English teacher, and I did my student teaching, and I really enjoyed that, and I really enjoyed working with the kids. But I also was helping out friends and family members going through different legal proceedings, most of that being family law matters, because most people represent themselves pro se in family law. I think in Colorado it's more than 50% of people who are in the family law court system are pro se.
I did not know that.
And I didn't know anything about family law, but I had friends who would just ask me to read over documents. What does this mean? And ask me for advice. And I would be very clear that I'm not practicing law or giving legal advice, but it just gave me some exposure into the legal system. And I decided that I really wanted to become a lawyer. And I thought that I wanted to become a family lawyer or work with children in some capacity. And my first year in law school, I did an internship with the Office of the Colorado Child Representative, and it's the office that basically coordinates and monitors all the guardian ad litem attorneys in Colorado. So
and describe what that means for people that don't know.
So a guardian ad litem attorney is an attorney who represents the interest of the child in a proceeding. And so they oftentimes will be involved in neglect cases, abuse and neglect. So where there's been an allegation of abuse or neglect by the parents or on behalf of the parents, and the court gets involved. And the guardian ad litem is the attorney for the child. So not the mom, not the dad, it's the child's attorney. And part of that internship was going around to various court proceedings and observing the guardian ad litem attorneys in court. And I would watch these, dependency and neglect proceedings, and they were heartbreaking. I mean, I sat through proceedings where parents were terminating their parental rights, giving up their rights to their children permanently. And after seeing that, I knew there was no way I wanted to go into family law. It's a very important field, and helping children is is extremely important in our state. But I just didn't have the ability to do that. I didn't have thick enough skin. And so the summer after my first year in law school, I got an internship working at one of the biggest medical malpractice firms on the plaintiff side in Colorado. And that was my exposure to the medical malpractice field. And what I loved about it is it really gave me a way to help people, but also learn about medicine. And I realized that I loved learning about medicine. And with every new case, there would be a different area of medicine, and I would get to have conversations with the best physicians in that field who were serving as expert witnesses on my cases, who would teach me about that area of the medicine. And part of my job as a medical malpractice attorney is learning something new every day. And that's why I love it so much.
That's such a great answer. And I will tell you, I know you don't like to talk about yourself much. That was a very beautiful intro into how you got here. I want to shout you out a little bit, in fact, a whole lot, and basically let the audience know why I'm so connected to you. And that is because if you've been following the show for a while, you know that my wife and I lost our son it'll be 2 years in June. And of course, worst process. Can't imagine going through anything worse. And through that, there was a question of what happened here? How could it have happened so quickly? Why did it go wrong? He went into the hospital with a stomach ache and never came out within 36, 40 hours. And so in that process, I had questions. And I didn't even know Paige. I didn't know you then. And you were a referral given to me by one of our attorneys here as being the best. And so you were kind enough to take a look at it. And what you brought to me, I can never repay. Because essentially, you helped my family and myself, and it's emotional, but it's important because you helped us get closure that it was going to happen, right? We were going to lose him regardless. So there was nothing wrong. So it was able to cleanse my heart and my soul of he should be here. So again, I'm your biggest fan. So all that being said, I know that not all cases of when people think they're hurt, there was malpractice. Can you kind of define what medical malpractice is and how it then translates to what people actually feel or what happens to them?
Sure. And just thanks for sharing that story, Dr. Hoven. I know it's difficult to talk about, and I really commend you and your strengths, throughout everything that you've been through with your son.
Thank you.
And it's, I really admire it. So what is medical malpractice? So I can walk through the basic elements of the claim, and it's no different from any tort claim, such as a car crash. You have to show that there was an injury, so that someone either sustained an injury, or in cases of wrongful death, it would be a death. Then you have to show that there was negligence. And in medical malpractice cases, negligence means a breach of the standard of care. Did the physician act as a reasonably competent physician under the same or similar circumstances would have acted when caring for that patient? And then in addition to showing that there was a breach of the standard of care, you have to show that that negligence, that breach of the standard of care, is what caused the injury or the death in cases of wrongful death.
Okay. So that causes it.
Yeah, and oftentimes that causation piece is the most difficult piece in a medical malpractice case. You might have a doctor who was negligent. For example, you might have a case where someone comes in and they have a mole on their skin that could be cancerous, and the doctor neglects it, doesn't do anything about it, and there's a delay in diagnosing that cancer. Breach of the standard of care. But if that patient, at the time they first came in to see that doctor, already had stage 4 cancer, meaning that the cancer had metastasized and spread to other areas, then that delay didn't make a difference. And so you don't have a medical malpractice case, even though the doctor breached the standard of care. So you have to connect all of the dots.
And what percentage of things that you hear, cases that you hear where people think something was done and maybe it was done incorrectly. They go in, like we see these leads all the time. I'm on the list where I get to read through them that all go to you for evaluation, where they say my husband, my aunt, my uncle, my brother went in for a procedure and something happened to where they died or they are maimed. Of all those complaints, what percentage of them are claims based on connecting all those dots and the difficulty it is? And then of those, what percentage of them actually get found to be like true crucible? They made it through the crucible of, yeah, it negligence, breaches the duty, and goes all the way to that end. So
it's a very good question, and you might be surprised by the answer. If we get 100 calls complaining of medical malpractice, it's likely that we might be able to take one of those cases, maybe, and maybe none, because it is very difficult to connect all the dots to show that there was medical malpractice and to show all the elements of the claim. And the first issue that we evaluate when we're screening medical malpractice cases is, what are the damages? And to understand that, you first have to understand how expensive medical malpractice litigation is. If we take a case against one physician to trial, we're likely going to spend anywhere from $150,000 to $250,000 in expert witness fees and other court costs. And that's not including the attorney fee, that's just the case expenses.
Wow.
And knowing that, you need to have a situation where your damages far exceed what it's going to cost to litigate the case, or else you're doing it for no reason because you're spending more than you could ever recover in a court of law. And that doesn't make sense to go through that process and to go through the stress of litigation and to spend the money when you know that you're just going to get nothing when all is said and done, even if you prove your case. And so another important aspect to understand about damages in medical malpractice is that we have significant caps in Colorado on damages, especially when it comes to the healthcare industry. And so in 1988, which happens to be the year I was born, that was a big year for tort reform nationwide. And tort reform is when, we were trying to essentially make it so we couldn't have big jury awards. We were scaring the public about the effect that big awards would have on healthcare and the insurance industry and on their premiums. And I think, these were the Reagan years, so it makes sense. In Colorado, we passed what's called the Healthcare Availability Act. And part of that act, it's got a great name, because whenever you're passing these laws that are going to screw everyone over, you've got to have a nice ring to it.
Name.
So it's the Healthcare Availability Act. We're making sure that healthcare is available to everybody. It's not what it is. What it is, making it very difficult for anyone who's been a victim of medical malpractice to bring a lawsuit.
And do these vary widely by state, or is it are all states pretty close?
So not every state, but many states have their own version of the Healthcare Availability Act. And then we have other states that are way more plaintiff friendly.
And plaintiff is the person who says, man, I'm injured, I'm hurt. They're the plaintiff.
Right. Yep. Plaintiff is either, in a medical malpractice case, either the patient or the patient's family in cases of wrongful death. And so part of the Healthcare Availability Act was they imposed two caps. The first is a cap on non-economic damages. Non-economic damages are pain, suffering, grief, loss of enjoyment of life. Those portion of your damages that you really can't easily affix a dollar figure to, such as your medical expenses or your lost wages. And so when they enacted the Healthcare Availability Act in 1988, the cap was $250,000. And the effect of a cap means, you take your case to trial, a jury decides, you know what? You suffered a spinal cord injury, you love to ski, you love to bike, you're never going to be able to do those activities again, you're going to need assistance every day with your daily needs. I think that your pain and suffering is worth $2 million. And after the jury awards that, the judge then applies the cap and says, no, you don't get that $2 million that the jury awarded. It's going to be $250,000. And so that's what we mean by a cap on damages.
And why would so a jury isn't given instruction like, look guys, the most that anyone can win is $250. So if you award more than that, who cared? Like, why would they allow that number to go over the cap? Is there some weight that it has to hopefully raise caps later? Or why aren't juries made aware of that?
You're not allowed to inform the jury about caps on damages when you go to trial. And so, we've all had different strategies in dealing with the cap. Sometimes we'll take a case to trial and we'll just tell the jury, award the amount of the cap for non-economic damages, but make sure you award every single penny of the economic damages. Other attorneys will just go for it and ask the jury to award millions of dollars. And, some attorneys have done that in order to challenge the cap. And challenges have been unsuccessful. But before I get into that, just a little bit more background on the cap. So in 1988, they passed that. And then they raised the cap one time since then, and it was in 2003. That was the only time they've ever raised the cap on non-economic damages. And they were very generous. They went from $250,000 to $300,000. So for the last over 20 years, the cap on non-economic damages in medical malpractice cases has been $300,000. It does not go up with inflation. That's what it is. So it's the same cap that it was 21 years ago.
That's insane.
It is insane. It is insane. And we do have other areas of law, like personal injury, where we have caps on damages. But unlike the medical malpractice cap, those caps are raised with inflation. They go up every couple of years. And the cap on personal injury non-economic damages is over $600,000 now with inflation. But medical malpractice will remain at $300,000 unless we change the statute through the actions of the legislature, or we pass a ballot initiative to either raise or get rid of the caps on damages. But it's really, when you think about it, insane that we've had the same cap for 21 years and they haven't made any attempts to raise it. Is
there a reason behind that? Because we've had both parties of government in power since then. So is it because they figure, oh, well, it should be made up on the economic damages side? Like, what's the rationale for not ever raising it?
There's not a rationale for not raising it. The problem is that the insurance companies, particularly the medical malpractice insurers, have made it impossible to take any action through the legislature to change the caps. They've essentially bought our state senators and House representatives. They donate money to their campaigns, and they tell them that, you need to do what I say when it comes to voting on bills. And for that reason, we have not been successful in passing a bill to either raise the cap or to eliminate the cap.
Wow. So let's transfer that then to economic damages. How does that work in our state?
In medical malpractice cases, and just as a reminder, economic damages are anything that you can clearly affix a dollar figure to, and you're usually dealing with past medical expenses, future medical expenses, or needs. So for someone who's paralyzed, they will have other needs with their home services, help around the house, help with cleaning. Those are also economic damages. And then you have your past and future wage loss in certain cases where that applies. Colorado, as part of the HCAA, has a soft cap on all damages, so it includes economic and non-economic, of $1 million. So what is a soft cap? A soft cap means that a judge has the authority to exceed the $1 million for good cause shown. If a jury, let's say a jury awards $3 million in a case, and that includes both economic and non-economic, it's up to the judge to determine if there was enough evidence presented at trial for there to be good cause to exceed the $1 million cap. So in cases where it's not a close call, you have a child who's got cerebral palsy and has a life care plan or expense needs of millions and millions of dollars that they're going to need to care for them for the rest of their lives. In those cases, it's pretty clear that a judge is going to say, yes, we're going to go with what the jury decided with economic damages, and we're going to exceed the cap. But you might have cases that are a closer call. I mean, the jury awards $1.5 million. In those cases, we're scared that the judge is going to say, look, there's only $1.5 million in damages. We're going to apply the $1 million cap.
Wow. And so with all this, again, I know that people out there have, and we deal with this here too, with people that were given a vaccine and then they have a horrible reaction to it. And they're like, I went in, I was fine. I got that, and within days, or especially the second round, if we're talking about the COVID vaccine, it's different if it was other influenzas or hepatitis or whatever. But when that happens, their world is changed forever. And so when someone goes through something like that, it's got to be really challenging for you as an attorney, knowing that 1 out of 100, it's not that something bad, horrible didn't happen, but for all the dots, as we said earlier, to be connected, it's such a tough crucible to get through. Have you found that even though you have to share that news 99 times out of 100, is there a role that you can play as a counselor, not their attorney, because you can accept their case, that helps them at least do what it did for me, which is kind of close that chapter with, okay, I guess this is how it has to be? Or what's the average interaction like for so many of these folks that you deal with?
It's very difficult. I think the hardest part of my job is telling someone that they don't have a case in situations where I'm telling them that there could be malpractice and we might even be able to meet the elements of negligence and causation, but because of the caps on damages, this is not a case that we can pursue. Those are tough because it's not like your situation where you're reviewing the case and you see, look, there's really nothing that could have been done to prevent this. It's just, yeah, you may have been a victim of medical malpractice, but financially we can't pursue this case because we're going to spend more than we can recover on your behalf. So those situations are hard. The situations where an expert reviews the case or it's clear from the medical records that there wasn't a breach of the standard of care, for some people that can actually be comforting because it's difficult to have that moment where you realize that your loved one's death could have been prevented or could have easily been prevented with better care. And that's a tough pill to swallow. But when you learn that the doctor did everything appropriately, or that there just wasn't anything that could have been done to prevent the injury or the death, then that can be comforting. Not everyone feels that way. I think certain people, they're very upset and they're very emotional about what happened and they're very angry, and they really don't want to hear that there isn't a case that we can pursue. And that's understandable too. Right.
Do you have any words of wisdom for them, again, on the counselor side, knowing that they're upset and you're not going to make them happy because you can't? Or are there resources that you say, hey, listen, while we can't help you, maybe you could go, maybe this is a resource, not necessarily even in a wrongful death or where there was a death that occurred, but where the person is maimed or they're forever changed. Do you offer that stuff to them in any way?
So there's a couple of options. One thing that I usually advise people that they can do is they can file a complaint with the medical board if it's a physician, or if it's a facility, they can file a complaint with the health department, because sometimes people just want to be heard. It's not usually about money. They're upset, and oftentimes people just they don't want this to happen to someone else. They want to prevent it from happening again. And so they can file a complaint with the medical board or the health department when we're dealing with hospitals or nursing homes. Now, I can't ever promise that the medical board's going to do anything. They'll review the complaints, and if they think that there's something there, they'll probably follow up on it. They'll send a letter to the doctor, and if it is a serious infraction, then they may take action against the doctor's license. So that's one option that I sometimes offer to potential clients when I'm not able to take their case. The other option is actually a new law that we have in Colorado called the Colorado Candor Act. That was a statute that was passed in 2020, I believe. It was enacted in 2021. And it was passed with bipartisan support. And Copic, who's one of the biggest malpractice insurers, was behind the statute. And Candor provides a voluntary option for physicians to have a conversation with their patients about adverse outcomes. So let's say a physician makes a mistake, and as a result, their patient is injured or their patient passes away. They can do what's called enacting a candor meeting or initiating a candor meeting. And they can have a conversation with the patient or the patient's family members about what happened and why it happened and what went wrong and what that physician is going to do to prevent this from happening to other patients in the future. And that conversation is completely confidential. And so the patient has to sign a confidentiality agreement, understanding that this is a confidential meeting under the Colorado Candor Act. And the patient is allowed to have representation if they want. And so they can hire an attorney to represent them through the candor meeting. And then they can have a conversation and the patient can ask questions. The patient can express his or her feelings about what happened. And the doctor can also tell his or her side of the story. And I have represented clients in a few candor type situations, and they can be very effective. When it's used correctly, it can be very effective. Sometimes it's not effective. But candor also, in addition to giving the physician the ability to have a confidential meeting with the patient, it also allows the physician to settle with the patient for money without having to report the settlement publicly.
Do they have to report it to their malpractice carrier, and is that where the money comes from, or is it personally from the physician or the hospital?
So usually the money comes from the malpractice carrier. So you would have to have both the consent of the physician and the insurance company to reach a settlement through candor. They don't have to report it to the National Practitioners Data Bank, and they don't have to report it to DORA, where it would be posted publicly on your physician profile.
Mm-hmm. And so for those cases, let's just say, does a physician accept candor only if they think or look at the record and say, ooh, man, something went wrong here? Is that when they would have this conversation? Or would they go, hey, we can talk about candor because I'm going to tell you nothing went wrong here? Like, how do they decide that?
It's a great question. So either can happen. So sometimes it'll be the physician's decision to reach out to the patient about doing a candor meeting. And the physician will reach out to the patient. They'll advise the patient that they can, retain their own counsel to do the candor meeting. And it's ultimately the patient's choice as to whether or not he or she would want to participate in candor. But most of the time, at least now, given that it's a new law, it's usually the patient or the attorney, me, reaching out to the doctor to see if they would be interested in participating in candor.
Are most of them interested, or do they understand it? I don't know if a lot of physicians, if it's a newer law, if they've even become aware, like, oh, if I admit anything, then I'm screwed. Like, what's their participation level?
So participation level has actually been pretty high, from my experience. And I think, for the physicians that are insured by COPIC actually did a really good job in, telling their insureds about candor and explaining it to them. And typically when a physician gets a letter from the attorney, what's the first thing you're going to do as a physician when you get a letter from an attorney?
You call your own attorney.
Yeah, you're going to pucker up and you're going to call your insurance company.
Yeah.
And so, when COPIC gets a call from the physician and the physician's like, I got this letter in the mail. It says something about Candor Act. I don't know what this is. I remember this patient. I remember that it was a bad outcome. Then the COPIC adjuster will understand what it's about and will know, how to advise the physician.
I see.
But no, to answer your earlier question, I have had situations in which the physician has agreed to participate in candor and participated in the candor meeting and said, look, I didn't do anything wrong. I stand by what I did. I stand by, my reading of the CT scan. And I'm not going to admit wrongdoing, and I'm not going to apologize. So that I've definitely seen that happen. And I think the reason that they use candor is that they want to basically just tell the patient again, I didn't do anything wrong. So we can have this conversation. It doesn't harm me to have this conversation, but I'm going to tell you again, like, I'm not admitting wrongdoing. And those can be very frustrating.
Very frustrating, I imagine. And as we kind of come to a close on this, I'm wondering, based on everything that you've shared, is there something that someone could do as almost a self-screening to say, I should call an attorney? Because again, if we're only taking 1 out of 100 cases, if that's roughly the number, people might do themselves a favor of saying, if it checks all these boxes, I should call an attorney. Is that a logical thing in a case like this, or are they all so variable that you just have to try and see what comes out from an expert? When does someone call an attorney?
You know, my advice would be call an attorney. You know, and sometimes when you call a firm and it's clearly a case that they won't take, you won't even get a phone call with the attorney, and that's unfortunate, but it's the reality of running a business. And I try to speak with people even when I know that they don't have a case. But there's really not a reason to not call an attorney's office if you have a question about care that you've received or that your loved one has received. I think from an injury standpoint, you know, if you're upset with your doctor, but it didn't cause any injury to you, then you would be wasting your time calling an attorney.
If you waited too long in the reception room and had to reschedule your appointment.
Exactly. And we get calls like that all the time. I mean, I think that if you really suffered an actual injury and it was a serious injury, and you have questions about the care, call an attorney. Don't hesitate. So I think the only situation in which I wouldn't advise to call an attorney is if you really weren't injured. You're just upset with your doctor. Yeah,
that's great advice. And if someone did want to reach out and ask you either about their case, find out more, or if they are young attorneys and they want to learn more about medical malpractice, is there a best way to get in touch with you? I guess you email. You can call the firm 303-733-6353 from that way, but as far as, would you prefer an email? Or
yeah, you could send me an email, and my email address is psingleton@ramoslaw.com. And I respond fairly quickly to emails if you have a question.
That you do. I've seen you respond like lightning. So, okay, here's my final question, and I ask all my guests this. If there's one piece of advice that you've either learned or been given along the way that's helped you to get to where you are at this point in your life, would you be willing to share it with us?
Putting me on the spot. I mean, I've received great advice throughout the years, and I'm just trying to think of something nothing's coming to mind. So I'm sure I could think of something better, but right now, one thing that comes to mind, you know, I received advice that you should always be yourself in the practice of law. And so, you know, you watch other attorneys in trial and you watch attorneys on television or in movies, and you think that you have to be like them when you're in trial and in front of a jury. But you're not doing yourself any favors to act like you're somebody else or try to be like somebody else. You really just need to be yourself and to be your best self so that you can advocate effectively for your client.
And I think that applies to everybody. I think if we're our true authentic selves in any situation, it's going to actually lead to our best, right? If we're in the wrong situation, by being our best self, then we're not in the right situation and we can find something better. So that is brilliant advice. I'm going to take that down and try to continue to apply it to my life. And in the meantime, Miss Paige, thank you so much for joining me. Thanks for taking the time out of your busy schedule. I appreciate you. And for those of you watching or listening, thank you guys. You are truly difference makers. And I hope that if you've heard this, that you would share it with someone. If the message struck home with you, or you know someone who might be involved in a situation like this, please share it, let them hear it. And if there's other things that you'd like us to talk about, let us know. If there's other types of guests that you want, let us know. So share it, talk to us, let us know, subscribe, do all the things that we hope that you'll do. And if you're getting value from this or any of our other content, and in the meantime, keep making a difference.